The Equal Protection Clause is broken, and it's holding transgender people back. Well, what's an Equal Protection Clause? Okay, you're probably right. I should take a second to tell you what this clause nonsense is before I try and convince you that it's broken. A clause is a fancy-sounding word for part of a sentence. More specifically, lawyers and politicians love a good run-on sentence, but sometimes their really long sentences are just confusingly long. So, in those instances, you toss in a few commas and then bada bing bada boom, you have little bite-sized clauses you can separate out. Now, back to the other part of that phrase, equal protection. It's pretty self-explanatory. The Equal Protection Clause is called that since it refers to these words. And, well, as you can see, it's a clause and it has the words equal protection in it, which explains the creative naming. Well, alright, I've explained what the Equal Protection Clause is in the most literal sense, but I don't really think that we're any closer to understanding what this clause is doing or why I said it was holding transgender people back. That explanation is going to take a bit longer, so I think it's best that I introduce myself before we go any deeper. Hello and welcome. My name is Mitch. I'm a queer trans law student with 5/6 of a JD, or a Juris Doctorate, and I think about systems from a critical perspective. If for some odd reason you care more about my qualifications, I have a resume on the internet, and you can Google it pretty easily. Lastly, I don't know everything. I'm going to get things wrong, but that's all part of the process. That's how we learn and grow as people, so let's learn together. You can find my sources in the description and on the screen, and if I miss something or you have something to add, you know where the comments are. In America, it all comes back to slavery. Slavery, our politics, and our legal system are all inextricably linked by virtue of the United States Constitution. The original Constitution of 1788 was written by and for white men who were wealthy enough to own other human beings as property. For these white men, slavery was an issue of great importance. It was so important that it consumed weeks of debate at the Constitutional Convention. Slavery was such an essential issue that the Constitution was at risk of not being ratified if it did not formally condone the practice of owning your fellow human beings as property. Wanting a government, and wanting to avoid another war, the dudes in wigs cut a deal and made slavery the law of the land. They knew what they did was wrong, but they did it anyways, because they valued not going to war with each other more than they valued the lives of the human beings they enslaved. Their shame prevented them from even including the words slave or slavery in the document. But slavery is slavery even if you can't bring yourself to say that what you're doing is slavery. Compromising with themselves, the founders wrote the 3/5 clause, saying that enslaved black people who could not vote could still be counted as 3/5 of a person when deciding how many representatives the state received in Congress. The slave trade clause, which prohibited the regulation of the transatlantic slave trade for 20 years, and the fugitive slave clause, which required that people who had escaped slavery were violently returned to their former slavers. These people, these wealthy white men, are writing the foundational document for our entire system of government, and their grand solution to slavery is going, I don't know what to do about slavery. We just really argue a lot whenever we talk about it. So, big idea. Let's just put slavery in the Constitution, but not call it slavery. And then we should also make it illegal to pass any laws about it for 20 years so other people besides us have to deal with that problem. Sounds like a good plan. To be fair to the long-deceased men whose documents we are presently shackled to, they didn't like their non-answer to the slavery problem either. There were in some, and I mean some instances, abolitionists at the founding, but they weren't the only people dissatisfied with the Constitution. Most of the founders had their fair share of reservations and critiques of the document. Some even outright hated it. In a letter penned by one of the more conservative founding fathers, Infamous slave owner and rapist-turned-president Thomas Jefferson offered this critique. Referring to the monarchs of Europe, let us follow no such examples, nor weakly believe that one generation is not as capable as another of taking care of itself, and of ordering its own affairs. Let us, as our sister states have done, avail ourselves of our reason and experience to correct the crude essays of our first and unexperienced, although wise, virtuous, and well-meaning councils. And lastly, let us provide in our Constitution for its revision at stated periods. What these periods should be, nature herself indicates. By the European tables of mortality, the adults living at any one moment of time, a majority will be dead in about 19 years. At the end of that period, then, a new majority is come into place, or, in other words, a new generation. Each generation is as independent as the one preceding, and that was of all which had gone before. It has then, like them, a right to choose for itself the form of government it believes most promotive of its own happiness. Consequently, to accommodate to their circumstances in which it finds itself, that received from its predecessors, and it is for the peace and good of mankind, that a solemn opportunity of doing this every 19 or 20 years should be provided by the Constitution, so that it may be handed on with periodical repairs from generation to generation, to the end of time, if anything human can ever so long endure. What that series of nightmarishly long sentences is trying to tell us is even the dudes who wrote the damn Constitution thought it was flawed and imperfect. They were, in Jefferson's words, an unexperienced council writing crude essays in a first attempt at creating a functional national government. The Constitution was not handed down to the founding fathers from the heavens, like Moses receiving the Ten Commandments. It was crudely and hastily written by a bunch of sweaty, drunk white guys in wigs one summer in Philadelphia. If you think about the original Constitution more like a fraternity's drunken summer project that they needed to submit before school started or they fail out, you get a better idea of what we're working with. I'm certainly not the first person to look at this mess and think, maybe we can do better? In 1861, after 73 years of not dealing with slavery, the deadliest war in American history erupted. The Civil War was about slavery. Anyone who tries to tell you differently is likely selling you the tired, racist talking points of the Confederacy and their equally racist lost cause. Luckily for those of us who are against slavery, the racist pro-slavery Confederates lost the Civil War and surrendered in 1865. In the same year, the 13th Amendment was ratified, kicking off Reconstruction. 13th Amendment, Section 1 provides, neither slavery nor involuntary servitude, except as punishment for crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. Section 2, the 13th Amendment, provides, Congress shall have the power to enforce this article by appropriate legislation. Look at that, they finally did it. They said slavery in the Constitution, and they said it was illegal. Well, mostly illegal. Coercive involuntary servitude, slavery, is still perfectly legal as a punishment for people convicted of a crime. If you know anything about the American criminal justice system, you probably know that involuntary servitude is still practiced today.
So 15 cents an hour pay, we're fooling ourselves. It is slavery. It's just by another name. Working in prison made me feel enslaved. It made me feel undervalued and unhuman, really. When I was working in the kitchen, I was paid 11 cents an hour. They didn't prepare me for an outside job. I did not have any money or support when I was released. For a period, I was homeless. The 13th Amendment has been a letdown for many, many millions of individuals in our country because it kept slavery in place. I just saw so many young, predominantly black men losing the prime of their lives to a correction system or a system of slavery.
So it doesn't take a lot to imagine what the still very Confederate South's response was. In 1865 alone, there were at least 3 documented mass lynchings, killing over 160 black people. It is certain that many more mass lynchings took place, and it is likely that hundreds more people were killed. Beyond the gross extrajudicial violence, the former slavers in control of the South reinstituted slavery in all but name, under the exception to the 13th Amendment. The former slave codes were passed into law as black codes, essentially criminalizing black existence in the South in order to force black people into the same position of involuntary servitude the 13th Amendment supposedly ended. In 1866, Congress federalized Reconstruction and placed the secessionist states under the control of the United States military. Now that is getting shit done. If you remember Section 2 of the 13th Amendment, I know, big ask, Congress shall have the power to enforce this article by appropriate legislation. In law school, that one sentence is a big deal. See, the sweaty guys in wigs that wrote the Constitution were really angry at the King of England when they were writing it. So they spent a lot of time and ink telling the government what it wasn't allowed to do. For example, here is the clause explicitly prohibiting the government from regulating the slave trade. This sentence, getting back to the Congress part of it, was added to the Constitution, and it told Congress, do what you need to do. That is an incredible grant of power, and that's what gave Congress the power to place the post-war South under military rule and declare that the governments then existing in the rebel states were not legal state governments. Hell yeah, kick those racist traitors out of government. They don't belong there. Unfortunately, progress was sporadic, and organized violent racial backlash was constant. In 1868, the 14th Amendment was finally ratified. This amendment fundamentally changed the Constitution, and it deserves an entire video that provides a deeper context than what I can provide now. But for today, let's stick to sections 1 and 5. Section 1 provides, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, or deny to any person within its jurisdiction the equal protection of the laws. Boom! There it is! We found the Equal Protection Clause, and it only took us 6 pages of script to get here. All that stuff about slavery and Reconstruction really does matter, though. It explains what the Constitution was changed in response to, and why the new Constitution provided such expansive authority to remedy subordination. This history isn't from some far-away time. It is mere moments ago. Ignoring this or omitting it from discussion aren't neutral, apolitical acts. They're choices. Choices that sever our present moment from its context. It's a choice that's often made out of fear. Fear that talking about race, especially as a white person, is an unnecessary risk. What if I say something wrong? What if I offend somebody? I don't want to hurt anyone, so it's just better if I don't say anything at all. You're right. You will say something wrong. You might offend someone. But that's life. We all make mistakes and hurt other people, even when we make efforts not to. That doesn't mean we give up. We apologize, we learn where we went wrong, and we put in the work to change. That's how we grow as people. Do you think black people are always comfortable talking about race? Hell no. When white people refuse to critically engage with the topic, we're upholding racism. It is racist to think that black people's job is to do all of the hard work about racism. It is all of our responsibility to educate ourselves and join in the work of anti-racism. that looks different for all of us, and it doesn't require you to be the loudest person in the room. But not engaging is a choice to maintain the status quo because it is more comfortable. That was a lot. Let's take a break here. You take a moment to breathe while I try and get us back to the present day. Alright, so what does the Equal Protection Clause even do? Well, today the Equal Protection Clause prevents the government from discriminating against people based on certain immutable characteristics, like race, national origin, alienage, sex, and having unmarried parents. It does not prevent the government from discriminating against people based on age, disability, poverty, or any other group of people, really. This weird set of suspect classes has their legal birth from a footnote in a 1938 Supreme Court case. Yeah, law is a nightmare, and sometimes you get an entire constitutional doctrine from a random footnote. Footnote 4, as it's known, comes from United States v. Caroline Products Co., a case about whether the government could prosecute this company for illegally selling filled milk cut with vegetable oil. You couldn't make this up, and if you tried, it would be too coherent to be law. Anyways, the footnote in the milk case gives us the test the Supreme Court still uses today to decide whether or not a group of people deserves the full protection of the Equal Protection Clause. Basically, the Caroline Products test asks 4 questions to determine whether a group of people counts as a discrete insular minority, deserving of suspect classification. First, has the group faced a history of discrimination? Second, does the group lack political power? Third, is the group based on an immutable characteristic? Lastly, does the characteristic have no bearing on the group's ability to contribute to society? If you affirmatively answer all of those questions, your group becomes a suspect class and becomes entitled to heightened legal protections. Because a suspect class has been subjected to discrimination and they lack political power, the Supreme Court reviews laws more carefully when they treat people differently based on differences that the court considers suspect. In the legal world, this is called the tiers of scrutiny. Originally, when the court made this whole tiers of scrutiny thing up, there were 2 levels: strict scrutiny and rational basis. Under strict scrutiny, the court is almost certainly going to strike down a law as unconstitutional, because in order to save the law, the government has to prove that the law is, quote, narrowly tailored to meet a compelling state interest, end quote. That's legalese for, you better have a really good reason for doing this, and you need to show your work. The government is rarely able to satisfy this standard, which is why strict scrutiny is often considered fatal in fact. If you trigger its application, you are almost guaranteed to lose. Rational basis is the precise opposite. As long as the government offers a single, rational reason for the law, it is fine, and courts won't really question the government for that reason. You can see how high stakes this test is from the milk case. It all comes from that one footnote. And if you win this test, courts all across the nation are supposed to vigorously defend your rights and question the government when it tries to treat you differently. If you lose, the court is going to defer to the government and likely trust that what they're doing isn't really all that bad. Currently, the law says there are 5 suspect classifications: race, national origin, alienage, sex, and having unmarried parents. Of those, race, national origin, alienage, and having unmarried parents get strict scrutiny. But sex, that doesn't get strict scrutiny. To explain here, I'm going to do a great deal of summarizing, but sex-based classifications get what's called intermediate scrutiny, meaning that's somewhere in between strict scrutiny and rational basis. You're probably thinking, wait a minute, why doesn't sex discrimination get strict scrutiny like all those other categories? They just made up a third option? For a long time, sex discrimination only received rational basis review. This is your reminder that women only got the right to vote in 1920. But lawyers like Ruth Bader Ginsburg pushed to have sex discrimination reviewed under strict scrutiny, synthesizing the rulings of United States v. Virginia, Craig v. Boren, and Reed v. Reed. The Supreme Court reasoned that laws based on, quote, harmful stereotypes, end quote, are unconstitutional, but laws based on, quote, real differences, end quote, between men and women are completely fine. As a non-binary person, I, rather predictably, have reservations about the gender and sex essentialist logic that is oozing from this standard. Catherine McKinnon, an influential dominance theory feminist, with whom I do not agree entirely, particularly her opinions on sex work, offers a useful critique.
The philosophy underlying the difference approach is that sex is a difference, a division, a distinction beneath which lies a stratum of human commonality, sameness. Its underlying story is, on the first day, difference was. On the second day, a division was created upon it. On the third day, irrational instances of dominance arose. Division may be rational or irrational. Dominance either seems or is justified. Difference is. There is a politics to this. Concealed is the substantive way in which man has become the measure of all things. On the first day that matters, dominance was achieved, probably by force. On the second day, division along the same lines had to be relatively firmly in place. On the third day, if not sooner, differences were demarcated together with social systems to exaggerate them in perception and in fact, because the systematically differential delivery of benefits and deprivations required, making no mistake of who was who. Comparatively speaking, man has been resting ever since.
This critique gives us the chance to reassess our assumptions and question how systems like the law can systematically manufacture and maintain differences in society. This isn't some off-ramp of nihilism and, nothing is real, nothing matters territory. It's a call to action, asking us to evaluate the status quo and work to change it. So, the Supreme Court made a mess of sex discrimination. And I can't really say they've been making a lot of pro-women decisions recently. So why don't we take a look at how the court has dealt with gay people under the Equal Protection Clause. I do want to provide a little bit of a side note here. I'm filming this in 2023 before the Supreme Court releases all kinds of decisions this summer. Some of those decisions could fundamentally change our rights, particularly as queer people. If you care to read more, there are links in the description. I do have some good news. In 2020, the Supreme Court issued its ruling in Bostock v. Clayton County, stating that, quote, it is impossible to discriminate against a person for being homosexual or transgender without discriminating against that individual based on sex, end quote. According to Justice Neil Gorsuch, this was the only result that you could reach from a plain reading of the text in Title VII of the Civil Rights Act, a consolidated and strengthened version of the Reconstruction era Civil Rights Act. I told you Reconstruction was important, and the Civil Rights Act of 1964, which prohibited employment discrimination on the basis of, quote, such individuals' race, color, religion, sex, or national origin, end quote. Gorsuch expanded, quote, homosexuality and transgender status are inextricably bound up with sex, because to discriminate on these grounds requires an employer to intentionally treat individual employees differently because of their sex, end quote. Neil may be conservative, but that's pretty damn good. What he's saying is that when an employer discriminates against someone for being gay or trans, they're also doing sex discrimination because they must know your sex in order to know whether you're gay. Gorsuch again.
Or take an employer who fires a transgender person who was identified as male at birth, but who now identifies as female. If employer retains an identical employee identified as female at birth, the employer intentionally penalizes a person identified as male at birth for traits or actions that it tolerates in an employee identified as female at birth. Again, the individual employee's sex plays an unmistakable and impermissible role in the discharge decision.
While Gorsuch's opinion is current law, his fellow conservative justices took issue with the fact that Gorsuch supposedly did textualism wrong. For those of you who are blessed enough to not know what textualism is, it's a popular yet substantively lacking theory of legal interpretation that claims judges can neutrally and objectively understand everything important about a law just from reading the words of the law. Textualism is the brainchild of a successful, decades-long political activism campaign to build durable right-wing power at all levels of the legal system. Originalism is a close relative of textualism with similar origins. It contends that our understandings of the law should be limited to the, quote, original intent of those who passed the laws, typically dead white men. There is, of course, more nuance to these theories, but I'm not here to do the Federalist Society's work by pretending like the details matter that much, especially considering how regularly supposed textualists and originalists on the Supreme Court conflate these distinct concepts when it's conducive to achieving the results that they desire. Again, there is another video's worth of content here, and boy oh boy, is it interesting and entertaining. But for now, the important part is that these theories of interpretation are political tools, used to dress up political and value-based decisions in the legal language of objectivity. Getting back to Bostock, Justice Alito argued that Title VII couldn't protect queer people because in 1964, when it was first drafted, homosexuality was considered a disorder and a crime, so protecting queer people would clearly go against the original purpose of the act. I remain unconvinced that the opinions of dead people who thought my existence should be illegal are valuable sources for rational legal interpretation, but I am not a Supreme Court justice, so my opinion matters a bit less. Since 2020, the composition of the court has changed significantly. Conservatives now have a 6-3 supermajority, and they are using it to get things done. I could try and read the tea leaves of the Supreme Court and predict what they're going to do next, whether they're going to overrule Bostock or not, but that's not really a productive use of time, in my opinion. Instead, let's dig deeper into Bostock and think about why it isn't perfect. First, the opinion never actually says anything about equal protection. Instead, the opinion focuses almost exclusively on interpreting what the words of Title VII mean. An equal protection violation is implied, given the fact that sex discrimination violates the Equal Protection Clause, and that Title VII is one of the ways Congress enforces the Equal Protection Clause. But legal implications aren't the same as legal guarantees. Even assuming that discrimination based on sexual orientation and gender identity remains sex discrimination, that just puts us back in the court's flawed understanding of sex discrimination. I don't say that to diminish the considerable increase in legal protections that Bostock brought, but to challenge that this is the best way that we can do things. Let's use the example of transgender women seeking access to a women's shelter to illustrate how this analysis breaks down. This has contemporary relevance. Just look at the United Kingdom, where transphobes and TERFs like J.K. Rowling are attempting to create trans-exclusionary women's spaces. Assuming the court is treating discrimination against transgender people as sex discrimination, a shelter seeking to exclude transgender women will likely argue that transgender women are biologically different from cisgendered women, and that difference justifies their different treatment. Unfortunately, this argument would likely be enough for the Supreme Court to rule against trans people. As we discussed earlier, the court has a strong biological essentialism streak going, and the conservative supermajority is not giving me any hope for change. In Geduldig v. Aiello, the court found that discriminating against pregnant employees was not sex discrimination because the policy in question only discriminated against a subset of women, pregnant women, not all women. This logic could easily be copied and pasted to the women's shelter example. Here, the court will say that, like pregnancy, some women experience the psychological and physiological experience of being transgender, and thus treating these different types of women differently is permissible and does not discriminate against women. This is a patently bad result for transgender people, and it probably represents the most we can hope for with the current court. In a worse scenario, the court might identify transgender women who have or are in the process of physically transitioning as a subset of women, whereas trans women or trans femme non-binary people who are not physically transitioning would simply be classified as men. Obviously, there is a much worse result if trans women are legally misgendered based on debunked biological essentialism. This example shows how ill-equipped our current conception of sex discrimination is for queer identities in the 21st century. So, forget sex discrimination. Why don't we get queer people recognized as a suspect class separate from sex? It's not quite that easy. As Rishita Aspani explains, the suspect class framework was originally intended to recognize present-day biases and afford particularly close judicial scrutiny to laws that might be based in those prejudices. In practice, however, it has served as a rigid gatekeeping mechanism for the court and is perceived as a disciplining force that reins in lower courts' attempts to expand the suspect class category to new groups. The suspect classes we have are the suspect classes we're going to get. While this legal framework may have been intended to recognize discrimination, its usefulness has declined over time. Part of that is that the Supreme Court has steadily narrowed the doctrine. But a big piece of that is that this conception of discrimination fails to capture the complexities of modern discrimination. Much of the court's current doctrine is focused on protecting discrete insular minorities from facially discriminatory laws. That is, laws that say they're discriminating, that discriminate in their words. This focus on discrete insular minorities and facial discrimination have been critiqued by scholars as ineffective and conceptually confused methods for identifying and remedying discrimination. In her seminal essay, Demarginalizing the Intersection of Race and Sex, Kimberly Crenshaw outlined how the concept of discrimination occurring toward a discrete insular minority excludes any consideration of the ways in which multiple marginalized identities intersect and complicate the analysis. Intersectionality has grown considerably since Crenshaw first wrote about it, but the example she gives of DeGraff and Reed v. General Motors is still one of the most poignant examples of her theory. I'll let her tell the story.
Now, the experience that gave rise to intersectionality was my chance encounter with a woman named Emma DeGraff and Reed. Emma DeGraff and Reed was an African-American woman, a working wife, and a mother. I actually read about Emma's story from the pages of a legal opinion written by a judge who had dismissed Emma's claim of race and gender discrimination against a local car manufacturing plant. Emma, like so many African-American women, sought better employment for her family and for others. She wanted to create a better life for her children and for her family. But she applied for a job and she was not hired, and she believed that she was not hired because she was a black woman. Now, the judge in question dismissed Emma's suit. And the argument for dismissing the suit was that the employer did hire African Americans and the employer hired women. The real problem, though, that the judge was not willing to acknowledge was what Emma was actually trying to say. That the African Americans that were hired, usually for industrial jobs, maintenance jobs, were all men. And the women that were hired, usually for secretarial or front office work, were all white. Only if the court was able to see how these policies came together would he be able to see the double discrimination that Emma DeGraff and Reed was facing. But the court refused to allow Emma to put two causes of action together to tell her story because he believed that by allowing her to do that, she would be able to have preferential treatment. She'd have an advantage by being able to have two swings at the bat when African American men and white women only had one swing at the bat. But, of course, neither African American men or white women needed to combine a race and gender discrimination claim to tell the story of the discrimination they were experiencing. Why wasn't the real unfairness law's refusal to protect African American women simply because their experiences weren't exactly the same as white women and African American men? Rather than broadening the frame to include African American women, the court simply tossed their case completely out of court. Now, as a student of anti-discrimination law, as a feminist, as an anti-racist, I was struck by this case. It felt to me like injustice squared. So first of all, black women weren't allowed to work at the plant. Second of all, the court doubled down on this exclusion by making it legally inconsequential. And to boot, there was no name for this problem. And we all know that where there's no name for a problem, you can't see a problem. And when you can't see a problem, you pretty much can't solve it. Many years later, I'd come to recognize that the problem that Emma was facing was a framing problem. The frame that the court was using to see gender discrimination or to see race discrimination was partial, and it was distorting. For me, the challenge that I faced was trying to figure out whether there was an alternative narrative, a prism that would allow us to see Emma's dilemma, a prism that would allow us to rescue her from the cracks in the law, that would allow judges to see her story. So it occurred to me, maybe a simple analogy to an intersection might allow judges to better see Emma's dilemma. So if we think about this intersection, the roads to the intersection would be the way that the workforce was structured by race and by gender. And then the traffic in those roads would be the hiring policies and the other practices that ran through those roads. Now, because Emma was both black and female, she was positioned precisely where those roads overlapped, experiencing the simultaneous impact of the company's gender and race traffic. The law was like that ambulance that shows up and is ready to treat Emma only if it can be shown that she was harmed on the race road or on the gender road, but not where those roads intersected. So what do you call being impacted by multiple forces and then abandoned to fend for yourself? Intersectionality seemed to do it for me.
This focus on finding the discrete type of discrimination someone faces misses the forest for the trees. Instead of broadening its perspective to see the full contours of discrimination, the court's doctrine attempts to narrow the concept of discrimination into simpler, well-defined categories. That life is complicated is a fact of great analytic importance. Law too often seeks to avoid this truth by making up its own breed of narrower, simpler, but hypnotically powerful rhetorical truths. As Patricia Williams explains, life is complicated, but the law doesn't like dealing with that reality. So we use language to create a simpler reality, where we can feel more confident in our mechanistic results. Courts are confident when they use the milk case test to find discrete insular minorities because they're treating discrimination like a math problem. a problem that produces the correct outcome when you put in the right variables. But as much as lawyers and political scientists and almost everybody else wants to tell you nowadays, life is not a math problem. There are not definite right or wrong answers to every question. Patricia Williams again.
Acknowledging, challenging, playing with these as rhetorical gestures is, it seems to me, necessary for any conception of justice. Such acknowledgement complicates the supposed purity of gender, race, voice, boundary. It allows us to acknowledge the utility of such categorizations for certain purposes and the necessity of their breakdown on other occasions. It complicates definitions in its shift, in its expansion and contraction according to circumstance, in its room for the possibility of creatively meta taxonomies and their wildly unpredictable offspring.
The choice is not between the rigid categorical truth offered by the current law and the complete abandoning of legal categories. There are so many possibilities between those extremes. The challenge is to engage in an ongoing examination of our categories and approach them with a flexible mindset that allows us to adapt in the pursuit of just results. This is only possible when we see the law for what it is, a powerful rhetorical construction, not the truth. The court's focus on facially discriminatory laws is a particularly egregious example of a powerful rhetorical truth. It wasn't always this way, and if you're thinking the Federalist Society has something to do with it, well, you get a cookie. Before the 1980s, the Supreme Court was concerned about laws with discriminatory results, in addition to laws that were discriminatory on their face. As recently as the 1970s, the court in Griggs v. Duke Power Co. recognized the importance of disparate impact analysis to achieve the purposes of the Civil Rights Act.
Achieve equality of employment opportunities and remove barriers that have operated in the past to favor an identifiable group of white employees over other employees. Under the Act, practices, procedures, or tests neutral on their face and even neutral in terms of intent cannot be maintained if they operate to freeze the status quo of prior discriminatory employment practices.
Under Griggs, addressing laws with discriminatory results is just as important as addressing laws with a discriminatory purpose. In 1975, the court upheld and clarified the Griggs framework in Albemarle Paper Co. v. Moody. In that case, the court set out the burden-shifting methodology for providing disparate impact discrimination occurred. This burden shifting is extremely important. When you sue the government for violating your rights, you are the plaintiff, the party bringing the suit, and the government is the defendant, the party defending against the suit. In the normal order of business, the plaintiff always has the burden of proof for their claim. That is, they are responsible for producing sufficient evidence and legal arguments to prove that their claim meets the standard of proof. Under a burden-shifting framework, that burden of proof can move from the plaintiff to the defendant. Let's take the example of employment discrimination. First, the employee who's discriminated against must present statistical evidence to demonstrate that the policy in question had a discriminatory impact. Once the employee demonstrates this, the burden shifts to the employer to prove that the policy or practice in question is job-related. Finally, if the employer proves that the policy is job-related, the burden returns to the employee to prove that the asserted business justification was pretext for unlawful discrimination. The employee can establish this pretext by demonstrating the existence of a less discriminatory alternative to the policy. This analysis was an extremely powerful tool for vindicating civil rights, as it allowed employees to successfully sue their employers. Unfortunately, in the early 1980s, the Federalist Society and Ronald Reagan simultaneously rose to power and began a concerted political attack on disparate impact liability. The Reagan administration quickly set its sights on nullifying Griggs. To this end, the Reagan Department of Justice, whose leadership was a who's who list of Federalist Society members, released a memo claiming that disparate impact analysis was tantamount to reverse discrimination. Griggs marked a tragic turn in American civil rights jurisprudence, on away from non-discrimination and toward an open contest for social and economic benefits conferred on the basis of race or other classifications previously thought to be invidious. Do you see how they use legal language to intentionally alter our perception of reality? During Reagan's presidency, the composition of the court changed considerably. He was able to successfully appoint and confirm a conservative majority to the Supreme Court, a majority that has only grown in strength over the past 4 years. Here is the conservative supermajority presently on the court. The Reagan-appointed court understood the assignment and got to work limiting the application of disparate impact analysis. It only takes a minor rhetorical shift in the Supreme Court opinion to fundamentally alter a doctrine. Here, the court undermined the burden-shifting framework by increasing the proof needed to prove discrimination by employees, while also lowering and completely removing the burden of proof from employers, essentially hollowing out the doctrine. Under this new standard, as long as an employer simply offered a business justification for the policy, it was likely to be upheld. The Supreme Court's narrow understanding of discrimination is exemplified by their opinion in Personnel Administrator of Massachusetts v. Feeney. Quote, discriminatory purpose implies more than intent as violation or intent as awareness of consequences. It implies that the decision maker selected or reaffirmed a particular course of action, at least in part because of, not merely in spite of, its adverse effects upon an identifiable group. In the court's eyes, knowing that your policy is going to discriminate against people and proceeding anyways doesn't prove that you intended to discriminate against them. To intend to discriminate against someone, you need to say that you meant to discriminate against them. This is completely nonsensical, and if I know my actions are going to hurt someone and I proceed to do it anyways, I intentionally hurt them because I consciously took that action knowing that it would result in their injury. That's a basic dynamic of intent, and you learn that as a first-year law student. But I guess that doesn't matter if you're on the Supreme Court. Great. I've spent the last 5,000 or so words criticizing and critiquing almost every aspect of the Supreme Court's application of equal protection. Even the mostly good bits got criticized. But I don't think it's helpful to only point out what's wrong with the current system and say it's bad. So let's take one last break and dig into some of the other ways we could do this. The way things are today is not the way things have always been, nor will it be the way that things always are. Our systems are as they are because of the well and ill-intentioned choices of the people that came before us. They may have chosen this system for us, but it is our choice, and not theirs, to maintain it or to change it. I obviously have plenty of discontent for the current system, so what's my recommendation for change? What big idea do I have to solve the problem? Perhaps disappointingly, I don't have one simple fix to solve the legal system, or even a straightforward answer as for how we can do equal protection better. What I can offer is a different way of thinking about the law, and if you've been paying attention, you'll already be familiar with it. As Patricia Williams remarked, acknowledging, challenging, playing with legal concepts as rhetorical gestures is, it seems to me, necessary for any conception of justice. By reimagining the law as a malleable rhetorical truth, not some everlasting reality, we can interrogate the usefulness of these truths, keeping their form as long as they serve us, and then recasting them into new configurations as our complex reality endlessly transmutes. In her feminist writings, Angela Harris suggests that we make our legal categories explicitly tentative, relational, and unstable, and that to do so is all the more important in a discipline like law, where abstraction and frozen categories are the norm. Like Williams's call to recognize law as rhetorical truth, Harris's call to make legal categories explicitly tentative, relational, and unstable suggests a way forward that is found neither in a strict adherence to legal truths, nor a complete abandoning of those truths. Instead, the call is to engage in a generative process of reimagination, actively assessing the successes and the failures of our legal categories, altering them as our world changes, intent on producing just results. When we recognize the constructed nature of these truths, we are empowered to choose a different path, to build a different legal reality, a reality that reflects the nuanced contours of all of our lived experiences, and not just the experiences of those who designed the system. This can all feel pretty abstract. So let's try and apply it in the example we used earlier. Women's shelters seeking to exclude transgender women. The traditional legal analyses would ask us to identify any real differences between cisgender women and transgender women, and then determine whether those differences justify their different treatment. The feminist legal critique offered by Williams and Harris does not begin with the mechanical application of a test. No, instead, their theory asks us to take a step back and consider why the women's shelter is seeking to exclude transgender women. Are they seeking to exclude transgender women because their experiences don't match with the shelter's definition of womanhood? With a theory of law that makes space for intersecting identities, we can see the relative privilege cisgendered women have compared to transgendered women, unlocking our ability to recognize that trans-exclusionary women's spaces, while claiming to provide benefits to women, are nonetheless perpetuating harm by reinforcing the patriarchal standards of what it means to be a woman. Once you understand that a policy's effect is to reinforce systems of inequality, it becomes readily apparent that the policy violates the Equal Protection Clause. This method of legal analysis is probably uncomfortable for most lawyers. Lawyers like certainty, and judges like it even more. As a profession, we don't want to make mistakes, because we know that mistakes have a price. It's good to get things right, and it sure feels nice to have a court say that you're right. But the problem comes when our desire to be right and our fear of being wrong give us permission to simply accept the legal truths we've been taught as given, unchanging aspects of reality. Like everything else in life, the law is ephemeral, existing in its current form only as long as we conceive of it as such. We have the power to transform the law, but we have to be willing to be wrong. There is no growth without mistakes. We are always going to make mistakes. We're only human. But that doesn't excuse us from the hard work of making things better. When we quietly accept the status quo out of a fear that we might get something wrong, make things worse, we are choosing to ignore the certain and ongoing violence of the current system in favor of our feeling of comfort. I don't have all the right answers, but neither does anybody else. I'm also not here to tell you that you're a bad, evil, no good person for being privileged and doing stuff that upholds systems of oppression. I'm a white person with most of a law degree. I'm plenty privileged, and I've done my fair share to uphold these systems. I don't think the binary distinction between good people and bad people is all that helpful in real life. Most of us think of ourselves as good people, but we're generally nice to each other. We help other people. We never try to hurt people. But we're not perfect. Sometimes good people say or do something that hurts others, even though they didn't intend to hurt anybody. Does that make them bad? For me, it's not about being good or bad. It's about doing your best in the circumstances, accepting when you hurt others, and taking steps to change. You need the courage to make mistakes and the will to learn from them. It's long past time to imagine a new reality. I can't believe we made it here. If you're still watching, sincerely, thank you. The essay part of the video is over, so no obligations to stay. This is more personal. For as long as I can remember, I've known that there was something I wanted to say. When I was 12, I started this YouTube channel, making unscripted Minecraft Let's Plays, the pinnacle of unique YouTube content in 2011. It's been a long 11 years since then. The internet has changed a lot, and so have I. In that time, I've discovered my voice, and I finally started to understand what I had to say. I knew that I wanted to make videos just like this one, and encourage people to imagine a different world. But I was convinced that whatever I made wouldn't be good enough. The video would lack in substance. The subpar editing would detract from what I was saying. I had convinced myself that in order to make videos in the first place, I needed to have already made videos. Good ones, at that. Only then would I be worthy to share my ideas. That's bullshit, and I only realized it because of YouTube. I don't know where I'd be if I'd be sitting here talking to you if it wasn't for me stumbling upon the amazing work of left-wing creators on this platform. This video is already long, so I'll just share one moment with you that gave me the energy and courage to see this through. Talking about the 7 deadly sins of art, CJ the X said the first sin was not making art.
And the yacht is NFTs. Your specific perception of the universe and the potentialities that lie under your skin, your little imagination lightning rod that detects like the ghosts of hitherto unrealized dreams, it's not replaceable. There's not going to be another one of you. So if you're not going to put in the work to make that idle fantasy that could have been real, it will not exist. Won't exist. You're depriving art of something that it literally cannot have without you. To be clear, it's not like if you don't have any artistic ideas, you have to figure some out and make them happen or else you're evil. It's that a lot of people do harbor creative passions and have genuine inspiration and real dreams, and instead of watering them, they let them die. And I think that's wrong.
In that moment, I realized CJ was talking to me. Instead of watering my passions, I was ignoring them, waiting for the day that the conditions would be right, that they'd magically start to bloom. The difference between me and the people on this platform that I admire was the fact that they made videos when I just dreamed about it. Now I'm here, and I'm so happy that I just did it. I wonder what's next. Thank you.
Help you feeling on a late night. I get on myself from a runaway train. Find some help so that I can never hate myself. You can see that I just berate myself. We keep going back out, I guess that we're done. You can't hear the words when I tell you that I'm done. I spent so many words broke trying to understand myself. I can't even get it how I felt. Help me when you don't have no one else. I can feel the pressure cause you put it on myself. I know I'll get better if I focus on my health. But I know regardless that I'm gonna go to hell. Help you feeling on a late night. I get on myself from a runaway train. I need to find some help so that I can never hate myself. You can see that I just berate myself.